CRPA just dropped another lawsuit. This time it's on CCWs in Los Angeles County. Let's talk about it. Hey everybody, welcome back to the channel today. In the long process that we have seen with CCWs in Los Angeles County, we are now at the point where a lawsuit has been filed. To talk us through it today, we have brought on an attorney with Michelle & Associates, Costas Moros. Costas, thank you for being on with us today.
Thanks for having me again, Kevin. It's always a pleasure.
Absolutely. Well, I wanted to talk through this today and get the full 360 degrees because you could really go all the way back to the Bruin decision. We've seen a decision from the Supreme Court. We've seen letters to all of the sheriff's departments go out urging them to get in compliance. We have seen advocacy at the grassroots level all the way up to the legal level. And so I guess tell me, what is it? Why are we now at this point where a lawsuit is being brought to the County of Los Angeles?
Right. So as people have been following all along know, like you mentioned, when Bruin came out, we sent letters to each county and some police departments that were issuing permits, basically explaining the ruling and saying what they need to do. For a lot of counties, the answer was nothing. Most, especially the more rural counties that aren't on the coasts, they were already effectively shall issue, and a lot of them issued permits with reasonable, maybe no expenses reasonable, but with expenses that weren't too ridiculous, along with reasonable wait times to get the permits. But there were some that dragged their feet. And we've tried for over a year now, since Bruin, to basically play nice. We send them letters, we put pressure on them, we do calls, but we try and basically talk these counties into complying. And we've had some success in that regard. San Francisco's issuing permits for the first time in years. Others have started, even though they're too slow. But we found that a few places, even despite our efforts, we're not improving. One of those is the Los Angeles Sheriff's Department. They take currently, by their own admission, in response to a Public Records Act request, they take about 18 months to process new permit applications. And then there's also Laverne, which we had sent a letter to in early 2023 about their high fees. They charge over, when you count the cost of the training and the live scan, they charge over $900 for a CCW permit, where everywhere else, even the more expensive places, usually are around $400 to $600, which is also unacceptable, but over 900 is next level. We're approaching $1,000 there for a permit. So while we know these are not the only places with these issues, there's a few other police departments with high fees and a few other counties that take long. We basically had to pick one and frankly make an example of them, get some case law precedent, which we can then use against others who are having these issues. And we're actually going a step further than that. Maybe we'll get to this in a bit, but we're also going to try and establish a precedent requiring California to honor permits issued by other states, CCW reciprocity as it's known, because we have a plaintiff that is a Florida resident that applied for a permit here, with Monterey County, I believe it was, but was denied because he's a non-resident. So we're looking to correct that as well. And I know that's something people have been asking for a long time.
Well, let's talk about the specifics of this lawsuit really quick, because nobody wants to wait 18 months. Nobody wants to pay high prices in order to get a CCW. But in California, people have waited that long and they have paid those prices. So what exactly is the argument that is being detailed here in this lawsuit, and why are they winning arguments?
Okay, so in the Bruin ruling, in a footnote, actually, the Supreme Court basically said that shall issue, the states that have shall issue permitting systems are acceptable. But within that footnote, they were careful to say, however, this doesn't mean that it's okay when a jurisdiction charges exorbitant fees or has lengthy wait times. And they basically said that would still be a constitutional issue. So that's our basis here. We're saying, look, the Supreme Court already said this is not okay. And by the way, California, when it comes to the wait times, California has a separate law which sets a 90-day time limit, or I guess now with SB2 it'll be 120 days, but still, even 120 days, when LA is at 18 months, they're just completely ignoring that California law. So we're essentially going to tell the court, when it comes to the wait times at least, look, we know there's subjectivity on what is and isn't too long, but you can just listen to California here for our purposes. 120 days is still kind of long, but we can live with that. Set it at 120 days, make them comply with it, and that will be sufficient for at least for the purposes of preliminary injunction. And that's where we're at on that. Now, as to high fees, there was a case, a district court case in the Northern Mariana Islands, which is a U.S. territory, which said they had imposed a $1,000 tax on handguns. And the court said, you can't do that. This is a fundamental right. That's an exorbitant fee. So when we're looking at Laverne's nearly $1,000 cost for CCW permit, we think that's a directly comparable precedent that is applicable here. Yes, maybe there can be some fee. We don't concede any fee is constitutional, but fine. Maybe you can charge some reasonable amount for the cost of processing these permits, but clearly over $900 is exorbitant. No other state, and in fact, most other counties, there's a couple cities that charge that much, but no other state charges that much, and most places in California don't even charge that much. So we think we will prevail on that as well.
I guess I'm also trying to think forward. Let's say, we remain optimistic and, we end up getting a preliminary injunction or getting a ruling that these things are constitutional. Are you saying that there is a waiting list in Los Angeles County of 18 months worth of people, or are you saying that, they are purposefully not processing the paperwork in a reasonable amount of time? And the reason why I'm asking is, say that we're successful in this lawsuit. Does that mean that a snap of the fingers and that wait automatically goes down to 120 days? What are the expectations that we should have if this lawsuit is successful?
I'm actually not sure if LA has said in letters to us that part of the issue is they just don't have staffing. They're probably not lying about that. I don't know how much they prioritized it, and I respect that they have other priorities as well. They have to, fight crime and all that. But this is a constitutional right. The state of California could do constitutional carry like over 25 other states have done, but they choose not to. So because they choose to require permits, they have to process them in a timely manner. And frankly, if this is honestly a resources issue, like they're trying their best, but they just don't have the resources, that's still the government's problem. They have to then, invest more resources into this to process these permit applications faster. There's no reason, and frankly, there's no reason it should take 18 months anyways, because even other slow counties like San Diego are at about 8 months to a year, which is still ridiculous and unconstitutional, but 18 months is just next level. That's part of why we picked LA is because they just had the most outrageous wait times. I think Alameda is comparable to LA in that regard, but no, I don't think any other county is.
What is the domino effect here? If you get a good decision out of a judge on Los Angeles County, does that automatically apply to all the other counties, or would separate lawsuits have to be filed after that?
So I'm hesitant to say until I saw what the actual ruling was, because sometimes they can get very fact specific. But if a judge were to rule, as we hope, that 18 months is unconstitutionally long and maybe describes what would be an acceptable wait time, especially if they set it at the 120 days California requires by law, because that's an easy marker since it's already state law, then we could take that to other counties and say, look, you have to comply with this too. A judge said it's unconstitutional, and maybe it'll go through appeals. We'll see. And if they don't comply with that, or if they don't make some effort to start to fix things within the next few months, then we could file additional lawsuits against them, which would be, frankly, easier at that point because we'd have the precedent we established in this case. Yeah.
And what
But it
about
would come down to each county. I could go to Alameda or what have you and say this, and maybe they'll say, okay, you're right. We'll do what we can to comply soon. Or alternatively, maybe they'll tell me to pound sand, and then we have to file a lawsuit. It'll be up to them.
Well, fair enough, and yeah, obviously these things are worth fighting for. So if it comes to that, then that has to be done. What of the movement through the court systems? I don't know if you feel this way. Maybe you can set me straight. I don't know if there's just so much litigation that it always feels like something is moving, or if these lawsuits are actually moving through the court system faster than they used to. What are the expectations for a lawsuit like this? Do you see getting any kind of resolution in a timely manner, or is this something, I've been talking to Chuck, and he's been saying, the Ninth Circuit is really trying to figure out how they're going to rule under Bruin. That's why you're seeing all of these irregular things happening with lawsuits in the Ninth Circuit. Do you see this one kind of having the same quick path to the Ninth Circuit, or something otherwise?
I think I'd like you to ask me that question again once we know which judge we're assigned to, because I think that'll matter a lot. We don't know which judge we're going to get. We might get one that's, sympathetic to our claims. We might get one that isn't a fan of the Second Amendment. And if it's the latter, it'll take longer, frankly. The first steps in this case, after we're filing the complaint today. By the time people are watching this video, it will be filed. And then in the next couple of weeks, we will be preparing and filing a motion for preliminary injunction, which hopefully this, if we prevail on that, then hopefully this will be at least preliminarily decided in the next couple of months. That said, we are asking for a lot in this lawsuit. It's possible we get part of it. So we're asking for four things. We're asking for the high fees to be resolved, the long wait times, the suitability determinations. Laverne requires a psychological exam, and we're challenging that, and of course reciprocity. So I could see a judge essentially saying, okay, I'm with you on the high fees and long wait times, but let's actually do more litigation on the reciprocity. That's a bigger issue on the psych exams. So it could be a sort of split decision on the preliminary injunction. I hope it's not. I hope we prevail entirely on the preliminary injunction, but I could see that happening if we have a judge on the fence who is with us on some things, but maybe not quite there yet on other things, if that makes sense.
Yeah, and there are several states that accept a California CCW as a CCW in their state. If I'm correct me if I'm wrong, but California doesn't accept any states CCWs. For how does that relate for this lawsuit?
We decided that it relates because since we're dealing with all the other issues around carry permit issuance in California, reciprocity made sense too, especially because some of our plaintiffs, like the ones that don't want to pay Laverne's high fees, have permits issued by Utah and Arizona. So we're comparing this to Obergefell, the gay marriage case, where a couple of the plaintiffs in Obergefell had gotten marriage licenses in other states, but then their state wouldn't honor that marriage license. And so we think that's a pretty direct comparison here, especially when Utah and Arizona, California might say, well, there's different requirements, so it's not fair. But Utah and Arizona, although they're constitutional carry states, if you want a permit issued by them, you do have to do the training course. That's why a lot of companies here that do California training courses will advertise that it's also valid in Arizona or Utah. So it requires the background check. It requires the training course. There's no reason for California not to honor these. So right now, if you aren't a California resident and you're coming to visit here, or you're just here some of the year, but not most of the year, you have no right to carry in California. That is not the case with any other constitutional right. No other constitutional right ends at state borders. So we're asking for one thing and then one thing in the alternative. So the primary ask of the court is going to be that California is forced to honor permits issued by other states. But failing that, if the court is not willing to do that, or if there's some reason not to that I can't imagine, we want at minimum for California to have to set up a system by which people who are not residents of California can apply in a timely and cost-effective manner to get a California permit. Because right now, a CCW permit by law requires you to be a resident of the state, or at least to work here before you can get a permit in California.
Well, this is kind of crazy. I mean, you got a lawsuit that seems on its face like it might be advocating for, which is still a huge swath of people, but the county of Los Angeles. But you really have secondary consequences here to other counties that are issuing slowly or have high fees, and then to the rest of the nation who might want to be able to carry if they ever do decide to come to California. Don't know if these people are moving to California or just visiting if you look at the U-Haul numbers lately. But I would say, Costas, looking forward, this lawsuit dropped today. Any final thoughts as we go forward?
No, just please support CRPA. This is probably the most complex lawsuit I've done in my over 4 years here now, because it has four different issues. It's basically four lawsuits in one. So that gets time consuming and confusing. So if you want to support CRPA, we'd greatly appreciate that, because the reason these things take time, and we wanted to file this months ago, is, we're obviously time and resource constrained. So your support is always valued in that regard. And people can reach out to me on social media if they have any questions. Yeah.
Well, I definitely want to thank you for taking the time. I know that we have another video scheduled with you later in the week, but thank you for coming on and informing us about this one today.
Thanks for having me on, Kevin. It's always a pleasure.
Absolutely. And if you like these videos, please, as always, be sure to like, share, and subscribe to this channel. Go ahead and click that notification bell so that you get notified as these lawsuits are dropped and as we come out with new videos. Thanks again, guys, and we'll see you on the next one.